Thank you very much, Stephanie. My name is Anya Linalesker. I'm the managing attorney for the American Bar Association Commission on Domestic and Sexual Violence. We are so glad that you are all joining us today for part 2 of our 4-part series on strangulation and its intersections with civil attorneys' practice as well as other professionals' experience working on this issue. Today's webinar is going to be focusing on the medical piece of this picture, and so there'll be a lot of background information and educational information as well as application to your work and practice. I want to thank the Alliance for Hope, who is going to be bringing you with their exceptional team of faculty this webinar, and I will turn it over to them in just one moment. I just want to share that if you were unable to make last week's webinar, part 1, you may find it on the American Bar Association website, and I will be placing that link into the participant chat box. You will also find a transcript available there for download as well. And if you were able to make last week's webinar and between last session and this one you have questions that came up for you, thoughts, a need for new resources that were not addressed, you may ask for those in the participant chat box, or you may submit a technical assistance request, which is just a request for help via the American Bar Association Commission on Domestic and Sexual Violence TA request form. I'll place that in the chat box, and I also know that Carly from the Alliance for Hope may share information about their technical assistance contact information as well. So with that, I'm excited to learn, and I will pass it over to you, Gail.
Well, thank you very much. We are so excited to be back and to see so many names that have joined us. So welcome back. We are grateful for your interest and commitment. This time around, we're going to be jumping right in. We spent a good 6+ months thinking about this presentation, and we're just so honored that the ABA was willing to partner with us and also working with the council. I think just planning for this made this presentation even better, and our focus, as you know, is for civil attorneys. So having said that, we've got 2 amazing people already on the chat room, able and willing and excited to answer any questions that you might have that we haven't answered before. So we also have some poll questions coming up. The other group that I want to thank is the Office on the Violence Against Women, because without their support, we could not be doing the things that we absolutely love and feel passionate about. What we decided to do is just give you and share one thing that we hope that you will remember from this presentation. And for me, it's about never letting a victim die in vain. Many of you heard my story and how these 2 teenagers impacted my life and had a profound impact in the work that I have been doing for the last 20 years, really trying to understand this thing called choking, as we used to call it, and what we could do to change the ending. So for me, is remembering not to let a victim die in vain, whether you have an informal or formal review process, always trying to learn how we can make the system better for survivors. So, as I mentioned before, we do have the Training Institute on Strangulation Prevention. It was launched in 2011. Our goal is essentially 5 things: bring awareness, improve policy, practice, and protocols, make sure we've got better outcomes, educate as many people as we can, which made me giddy today because I saw a lot of folks that I did not know, and it's really nice to see all of you saying hi from all over the United States. So that's pretty darn cool. And then, of course, multiply, 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 and make new friends that can help you in this effort. So speaking of making new friends, I would like to welcome Margaret to say hello.
Good afternoon, everyone, and we appreciate your returning for the second session of our webinar. I would hope that you will be very creative in your pleadings as civil attorneys in trying to address the legal needs of victims of strangulation.
Thank you, Margaret. And Alexandria?
Yes. As either you will learn or you have learned, a survivor's initial presentation of symptoms or lack thereof is not a reliable indicator of the outcome. So I say to all civil attorneys, you must screen and ask questions And we will provide that list in the next 2 sessions. You need to assess and you need to document, because we're not really talking about necessarily a crime. In Ohio, we don't have a criminal law yet, but as a civil attorney, and I know Margaret talked about that last time, with whatever you are doing, you need to screen, assess, and document, and ask the right questions. Thank you and welcome.
Thank you, Alexandria. Okay, so what we're going to cover today, the medical piece. This, to me, is one of the most important pieces. I have to kind of laugh out loud because as we were going through PowerPoint slide after PowerPoint slide, it was hard for us to take any slide out. But this time is about the medical piece, and this is where it really clicked for me. And it made me realize, oh my gosh, how little I knew and how many cases I messed up as a prosecutor, because I was really focused on the visible injury, and little did I know what was more dangerous and what was lurking underneath the skin was life-threatening. So we're going to go through everything that we believe attorneys need to know. This is not going to be the medical class. This is going to be Medical 101, plain English, so this way you can share it with others so they can understand. We've got a couple of poll questions. First one, true or false? Most victims of strangulation have symptoms. Okay, looks like it's slowing down just a tad, or a tad. I'll leave it up to Anya whenever she wants to broadcast the results. Well, I think we're about ready. Okay, what I'm seeing is most of you have said false. Well, it wasn't meant to be a trick question. The answer is true. Most victims of strangulation do have symptoms. The problem is most of us are not trained and we don't know what to look for, and victims don't tell us. They have a tendency to minimize. And a recent study that came out from Australia, they identified through forensic exams, over 1,000 forensic exams involving victims who were strangled, that 70% of them had one symptom, at least one symptom, maybe two. So that's what we're trying to say, is paying attention, looking for those clues. So let's go to, I think we've got a couple of more polls. Did you attend the first session? And I was just advised that all of you get to see real time the results of the poll. So most of you did attend. That's awesome. Some of you did not, but probably will be watching it. And that part one is foundational. All the things you need to know before you even get to the medical piece. Okay. I think we're ready for the next poll question. I would love to know who you are. We're hoping for a multidisciplinary group, but obviously our target audience, civil attorneys. Ooh, I love what I'm seeing in the chat room. Wow, what a diverse group. This is awesome. Because each one of you plays a very important role to bring the whole team together. Wow, this is awesome. That's interesting. Violent death reporting system from Indiana. Ryan, that's an interesting position. Thank you. Okay, mostly legal, and we have our multidisciplinary team. Fantastic. I like this title, Domestic Violence Reduction Advocate. Oh, I like this one too, Domestic Violence Advocate from the Housing Authority. Wow, very cool. Okay, well, I think we're ready to go to the next poll and or get started. I think we did that one. I will go ahead. Can we advance it to the next one? I guess I can do that. Okay, here we go. What do you need to know? A reminder. If I understand it, looks like most of you attended the first one, but this is something that we usually challenge people when they come to our advanced course to come up with your own definition of strangulation. We make people actually practice it. This is the medical definition that our doctors gave us, but I generally like to say it's external pressure to the neck by any means that's going to obstruct airflow and or blood flow. You have to be able to just rattle this off so this way you can explain it to your client and other people that you're working with. The big misconception is everybody thinks strangulation has to do with airflow and they forget about obstruction of blood flow, so it is both. That's the big key. The other one, we said it before, and we're going to be saying some things over and over again because it comes up a lot. And now it's going to be your responsibility to pay this forward and share this with others. Strangulation is not choking, but here's the caveat. Victims will call it choking. I've now embraced that completely. Always use the words that they use, and even if they use the word choking, I would recommend that you ask them what that means to them. Working with survivors, conducting probably 5 focus groups just on strangulation alone. Even choking means different things to different people. But choking is going to be accidental. Strangulation is going to be intentional. Make sure you know the definition that your survivor, your client, is using. Now, when we talk about strangulation, we are including suffocation within that definition because it's an obstruction of airflow. But suffocation can appear in many different ways. In one study that we did with restraining orders, 60% of our clients said they were also suffocated when they were strangled. And we see suffocation in many different ways. The obvious one is when you are covering the mouth and or nose. Some of the statutes actually require you to cover both in order to have suffocation. I want to go to anatomy. And this is where I asked Dr. Dean Hawley and Dr. George McLean to make it very simple for me. And at first they were teasing, and they go, Gail, look at this chart. We got all these terms for all these vital parts of the neck and head, and you need to understand all of it, and we had to actually learn it in Latin. But I go, we don't need all that. What we do need is the basic stuff. So as simple as we need to know the good blood goes up, definitely goes to the brain, goes in through the carotid arteries and comes out the veins. It gets distributed through capillaries and then venules, and it goes to all parts of the body because the body needs oxygen, the body needs blood to survive. But you can also see in this demonstration, which hit me the first time I saw it, and I said, oh my gosh, this really does show how vulnerable the neck is. And you can see the vein, which is essentially taking the bad blood from the brain all the way down, lungs and heart, recirculating it, getting good oxygen, and then having that circulation that you can easily compress that. So this is really to show you all the parts of the neck and brain and how vulnerable the neck can be. Thyroid gland. We started to include the thyroid gland and spend more time on the thyroid gland as a result of some of our focus groups. What we saw as far as a pattern in each one of our focus groups is that survivors were telling us about some of their long-term consequences. And many of them, I would say at least close to 60 to 70% in one focus group said that they were having problems with thyroid issues. And if you look at the neck, the thyroid gland is right there. And what I have learned from the doctors and the nurses who I have worked with, and I keep picking their brains, is that when you put pressure on the thyroid gland, it releases a lot of hormones. And I have received an article from Dr. George McLean and also Dr. Bill Smock about the thyroid storm, where people have actually died as a result of the thyroid gland and the release of too much. So it's something to pay attention to. As I've been reading and rereading articles with respect to the carotid dissection, in one study, the women, 3 of them who had a carotid dissection also had high levels and issues with their thyroid. So you might want to add this to your questions as you're interviewing your clients and asking them how they're feeling and the issues, the health issues they've had to deal with. We came up with this vital neck structure, using it as a tool to train, a tool that you can use in court, something that you can use to explain what's happening to your client. So a couple of basic things, and the rest of it you can ignore. We're going to go through the carotid artery. It's color-coded. You see a little arrow, number 1. Number 1 is good blood going up. Then number 2, it's bad blood going down the veins. Number 3, you're going to have the hyoid bone that's holding up the tongue. Big, interesting thing. I like forensic files. I like everything to do with cold cases. I watch all these shows, NCIS, you name it, I watch it. And all the time you will hear, especially in murder cases, that the fracture of the high bone was there, therefore that they were strangled. What we have discovered in the research and things that are not published and working with survivors is that you can fracture the hyoid bone. You can also fracture a thyroid cartilage, cricoid cartilage, and tracheal rings and be alive. For a while there, everybody thought if you were strangled, you were dead, and if you survived, you were fine, and you did not have any internal injuries. But we're getting those case studies being published in medical journals, so that's what we want you to pay attention to. We are not going to be showing this video today, but we want you to know that the choking game video, which is a really good illustration about what is happening to the brain as pressure is being applied and blood flow is being obstructed, that it will give that person, especially if they're playing the choking game, this what they call a warm, fuzzy feeling, which they've described as nothing more than your brain cells dying. So a lot of folks think this is the choking game, but if you go to the CDC website, they document how many cases of the choking game where somebody ends up dying from the age 6 all the way to an adult, and as you get older, they're doing the choking game for sexual reasons, whereas the young kids are doing it to play this choking challenge. They call it all different things, but the results are the same. You're going to have loss of consciousness, you can have brain death, and or you can have death. And if you think this is not happening, and this is the reason why I like to talk about it, is that there is no public awareness campaign about the danger of the choking game. This is the closest thing I could find. And when I asked my kids, when I learned about this, did they hear about it? Did they see it at school when they were in like in the 5th grade. This is when I learned about it. They're now 30. I asked them. I said, hey, have you seen this? He goes, yeah, they're playing this on the field. And I go, oh, my gosh. And then I decided, okay, time to call the school and talk to them about it. And I've been trying to educate everyone, share this information, because in your immediate circle, you have the ability to educate, bring this awareness, and hopefully prevent somebody from dying. I do a Google search, and I have a Google alert that tells me about these cases. And on average, I find 1 child per month who ends up dying as a result of playing this choking game. And those are the ones that I know about. A lot of these cases do not even make it to the newspaper. And it came home about 5 years ago where my husband told me that one of his coworkers' son ended up dying as a result of this. He played the game. He ended up passing out. He fell on a glass table. The glass table broke, and a piece of glass went into his neck, and he ended up bleeding to death. And I haven't been able to forget that, and it's just one of the reasons why I think it's important. But that video will help you understand it even more so. And if we have trainers on this call, this is a really good training video that you can use as you are educating others. So the other question we get, well, how much pressure do you need to obstruct blood flow or airflow? And the answer is very little. But what we're trying to find out when we're working with someone, trying to document what they experience, is how much pressure was applied. And we generally will ask the question on a scale from 1 to 10, 10 being the most pressure. Can you tell us how much pressure you think was applied? Was it continuous? Did they start squeezing more? Did it happen more than once? We do get those who are very curious about how many pounds of pressure to include the veins, the carotid arteries, and airway. And it does look like my screen got distorted here. Now, one thing I want to share about pounds per pressure is that some experts don't like talking about this, especially in court. Some experts love talking about this to help you understand how little pressure it takes. I generally recommend to experts who testify in court, there's no need to go into this. I would just say it takes very little pressure to occlude the vein, artery, and as you go for airway, it's going to take more. But this example that Dr. Bill Smock likes to use is that he'll show that it only takes like 6 pounds of pressure to pull a trigger of a gun. So those police officers who are here will probably identify with that. Only 20 pounds of pressure for a soda can. And then if you think about a handshake for a male, average male, and it's kind of fun to do this exercise when we're doing training because sometimes people will compete, and then you can really see the strength of one hand. And then just try to imagine somebody who is angry, who's upset, who is full of rage, threatening to kill someone, how much pressure, continuous pressure, is being applied. So this slide is just meant to be an example and an illustration. I did want to talk about, and we wanted to talk about this, I can't breathe. All of us saw that on TV with George Floyd saying, I can't breathe. We also saw that in the Eric Gardner case, and we're seeing it more as we're realizing there's a lot more of these cases out there. So I did want to talk about I can't breathe, and what ends up happening is that there is this huge myth. Everybody thinks, and we saw it in the George Floyd situation, if someone is talking, if someone is screaming, if someone is crying, there's this myth that that means they're breathing. And if they're breathing, there is no obstruction to airflow. But people tend to forget about blood flow can also be obstructed. And people tend to forget that you can still have partial obstruction of airflow, and that still means that your brain is not getting sufficient oxygen to the brain. Because after the brain takes what it needs, it really does become like bad blood. There's carbon dioxide, and that needs to be circulating continuously in the brain and the body. So positional asphyxia is generally putting pressure on someone's chest, torso, sitting on them, or you could be putting pressure on their back. The end result is that you can't have a deep breath. You're not breathing completely. And that's what you have with positional asphyxia. There is a great document that was put together back in 1995 that we are going to provide you as an attachment and a resource, and this explains it beautifully, and it's the best document out there that I've been able to find. So the next question we normally get is, well, how do you cause a loss of consciousness? Well, as I mentioned before, you're talking about blood flow and or airflow. When I looked at the military manual, they have very graphic descriptions on how this plays itself out. But generally, if you block off blood flow, it's only going to take about 10 seconds or less. And there's research study that was done in 1944 where people in jail volunteered to be part of the study, and they were strangled essentially repeatedly, ultimately, collectively about 500 times, and they ended up passing out within 6.8 seconds. That was the average. But overall, most experts will testify blood flow. If it's not happening, you're going to pass out in 10 seconds. If you impede airflow, you're talking about 60 seconds, and this varies because the minute you feel like you can't breathe, you are going to struggle and you're going to fight. And that's what's the interesting thing that happens in these restraints with law enforcement. So pressure is being applied either to your neck, to your body, or both. You start to sense, I can't breathe, or your brain is telling you, I need more oxygen. You're going to resist. And the minute you start to resist, there's going to be even more pressure applied to you to try to control the situation. And it's just disaster ready to happen. So a lot of times, and this is one of the first things I learned when I started to get my medical class, is a lot of the victims, when we would ask the question, did you pass out? Most of them said, I don't know. And I initially thought, well, when the victims say, I don't know, could this be recantation already happening at the scene? Is this a credibility issue? What's going on here? Little did I understand that when a victim says, I don't know, that is actually and should be used as corroboration, because what is happening when it comes to loss of consciousness is the first thing that goes in the brain as far as not working because there's no oxygen. It's the hippocampus. And I love that word because the hippocampus is responsible for recording memory. So think of it. If the blood is not flowing, the brain is not working, parts of the brain is not going to be recording, therefore they're not going to remember. So that's why you have to look for the clues. And so generally they're going to remember things that happened just before they passed out. And then in this research study that we will also share with you is that after they start to feel the signs of loss of consciousness generally happens within 1 to 2 seconds. So someone says, I started to feel dizzy, lightheaded, disoriented, stunned. I started to see stars. My vision went from color to black and white. I started to see a narrowing of my vision, like tunnel vision. They will describe even hearing changes. So what we're going to be looking for is, what do you remember? Tell us what you do remember. And many times when I've asked that question in the past, they go, well, I remember we were having an argument in the kitchen, and the next thing you know, we are in the bedroom. So there is also a lapse of time, a change of location. And when there's a change of location, most of our victims have reported being strangled in the bedroom. You have to be thinking about sexual assault. And a change of location means, okay, if there was sexual assault, what happened to their clothes? Some victims are going to urinate and or defecate. If you have urination, that means they passed out. Urination is going to come after they've passed out, and defecation is also going to happen after they pass out. Urination usually happens after continuous pressure at the 15-second mark. Defecation happens at the 30-second mark on average. And then you also end up doing an exam from head to toe because there could be injuries that they don't know how they got, and unexplained bumps in the head or injuries to the body is another way of telling you what could have happened if they were restrained or dragged somewhere else. So I like that little cheat sheet. And here's the hippocampus. It was like one of my first favorite medical terms. I don't know if I think I've got it. Here's what I want you to remember. It's not a hippo on campus. This is where you guys can all laugh out loud. I feel like I'm talking to myself here. But hippocampus is going to be responsible for memory. So if you look at brain death by blood flow, the experts and the literature says that you can have someone die as a result of just blocking the blood flow in about 2.5 minutes or less. When it comes to airflow, most of the experts will testify to 4, 5, I've seen as many as 6 minutes. And as you know, in the George Floyd situation, they documented 8 minutes and 46 seconds, as I recall. So a lot of things could be happening. There's continuous pressure. There is someone who's fighting back. And the minute that pressure gets released and pressure gets reapplied, that clock starts to tick again. So we're going to be looking for those signs and symptoms, assuming that the victim doesn't remember, assuming that the victim may minimize. And so we have created these tools for strangulation involving the adult victim and also the child. The signs and symptoms are generally going to be the same. These are documents that you can either download from our website, or we're going to be making part of your toolkit as part of this webinar series. So a couple of things that I had to learn, and this is why we're going to be looking for these things that I never knew existed, which once I learned this, I was quite frankly mad. I feel like, why didn't they teach us at the California District Attorneys Association? If you're going to be handling domestic violence cases as your assignment, why didn't the office give us a class on all of the possible injuries you can have from head to toe? What are those signs and what are those symptoms? It was like unheard of. I used to go to like every single conference on domestic violence because I was so afraid of failure, so afraid not to do this right, that I wanted to just learn as much as I possibly can. And at that time, there was no such class. But here's something that happened, and people have died from this, where they've had pulmonary edema. I didn't think this was possible, but essentially your lungs end up filling up, and it's as if you're drowning. You could have aspiration pneumonitis, where some victims have reported being nauseous or they vomited. They could have a seizure, and in sort of the scheme of things, I'm going to show you a timeline, is that many victims will have a seizure, especially if they've released that pressure to the neck, because it's kind of like the brain rebooting itself. And then sometimes if you don't release pressure, you can still have a seizure. So, I mean, if you kind of think about this, there's only one reason you would continue to apply pressure to somebody after they passed out, and that is your intent to kill. So that's why when we see urination or defecation or petechiae, or we find out about a seizure, we recommend everyone thinking about this was an attempted murder. And then last but not least is victims have reported pneumonia, and some have died as a result of this. Very heartbreaking, but we're seeing in some of the statutes is that some of the strangulation statutes do include strangulation with involving a pregnant victim, or they include that as part of aggravation. I would definitely, as a civil attorney, make this a point. So miscarriages have happened. It's going to be hard for doctors to testify to that. So that's one of the reasons why some of the statutes include strangulation, and then another element is going to be the victim who is pregnant. So another thing to know about is those tiny little red spots called petechiae. My second favorite medical term, because petechiae represents a life-threatening injury. So this is where I wanted to talk about non-fatal and near-fatal. Not every case is going to be a near-fatal situation. Depending on the circumstances, how much pressure was applied, did someone fight back, were they able to escape, were they able to run before damage, serious damage was done. But when you get to petechiae, the urination, the defecation, we definitely, and our medical team considers that a near-fatal strangulation case. So how does that occur? This is like the balloon. I mentioned it last time, but for some of you who weren't on that first session, this one is worth repeating. So you got pressure that is being applied to the neck. The veins are occluded. That means they're blocked off. but the carotid artery, which is generally protected by the strap muscle, it may take a little bit longer to get to the carotid arteries, but what's happening in the meantime is blood is going up, but it's not coming back down. It's like a balloon. If you blow air into the balloon, and you keep blowing air into the balloon, and you keep blowing air into the balloon, eventually that balloon is going to pop. So as you can see in this demonstration, which I kind of like because it made me understand it, is that the brain is there in the skull, and it's like a tight fit. Then you start thinking about pressure and blood going up and not coming down. It's like a sponge that has too much water. It starts to expand, and as it starts to expand, it's expanding against the skull of the brain, and then eventually it starts to pop. So the brain is bleeding, and at autopsy you will see evidence of this. So unfortunately, and only one time was necessary, Dr. Dean Hawley, who was a pathologist, he insisted as part of my training and learning, if I wanted to become a specialist and an expert in this field, to see an autopsy, and sure enough, there it was in the brain. Now, we're not going to be showing you autopsy photographs because it's really too graphic, but I want to share this with you. As we started to learn about head to toe and the examination, it's really true. And what Dr. Smock and others on our medical advisory team said, you could get petechiae from head to toe, and you really need to be looking at the ankles. And I went, okay. I never thought about that before. And Trixie Colburn, who I'm just so proud of, she was an advocate. She attended one of our trainings, and she was doing a restraining order. And all of a sudden, she goes, oh, I'm going to apply what I learned. And she started to ask the victims who were seeking restraining orders, you know, I'm just going to do a quick exam. I'm going to look from head to toe to see if I see any signs, to see if I see any petechiae. And she was the first one to send us photographs of the petechiae to the ankles. And essentially what the victims reported was that pressure was being applied to their neck. They ended up passing out. They were trying to escape. They were being restrained. Then they sat on top of them, and then they applied pressure to the neck as well. So they had petechiae to the ankles and to the face. So now let's go through the symptoms. One of the things that we do see is voice changes. 50% of the time you may see that. That's as a result of nerve damage. That could be swelling. And it could be a raspy voice, a hoarse voice, or they completely lose their voice. The big one, and I think this is where most victims who may not initially call police may then seek medical attention, is when they are starting to have swallowing changes. They have reported that it becomes so painful and difficult to swallow that they can't eat or drink. And they've reported this happening for weeks at a time. And so this is when I've seen more victims seek medical attention when they're having swallowing problems. In our study, which we will be sharing more next class or next webinar, part number 3, is that victims do end up reporting having breathing changes, not just at the time that it occurred, but it happens 24 hours later, 36 hours later, and they feel this discomfort. And then when swelling starts to happen in the neck, it could be difficult to breathe as well, and you can have some delayed consequences. The big one, though, that turned everything around for me is that the lack of oxygen to the brain can cause an anoxic injury to various degrees. One way it shows itself is that victims can become hostile and or combative. And you see that too when suspects have been with the police and all of a sudden the carotid restraint is applied. The requirement is that when you apply the carotid restraint, which is to cut off blood flow, and they immediately pass out, you need to handcuff the suspect. That's a requirement when San Diego had its policy. Fortunately, they've completely banned it now. But the idea was if they go down fighting because of lack of oxygen and they start to panic, that they're going to come to fighting. So the lack of oxygen causes that aggression. That lack of oxygen causes the amnesia. And depending on how long the brain has been deprived of oxygen, it can actually have some permanent personality changes and or disorders. So then I wanted to learn more about this. I go, what are the symptoms of an anoxic or hypoxic injury? And here's the long list. memory changes, concentration, sleep problems, headaches, depression, and anxiety. And I went, holy cow. I bet you guys are thinking the same thing I'm thinking if you haven't had this training before. This looks like all the symptoms of PTSD. So then you have to wonder, do our victims have PTSD, or are they suffering from an anoxic brain injury and or maybe a concussion, because most victims are not just strangled. They're beaten, they're kicked, they get their head banged around against walls on the floor. So what is really happening, and are we misdiagnosing our victims? So I want to give you an example of a case study that happened in San Diego, and with Tanika's full permission, I'm sharing it with you. This is Tanika. Tanika was a client of the San Diego Family Justice Center. She came in seeking a restraining order to leave her husband. She had been strangled twice in her relationship. The first time she was strangled was on her honeymoon. The second time was 6 months later. And when he strangled her again, she described it as if he was trying to pull her neck off her body. It was a chokehold because he came from behind and she didn't even see it coming. She described the pressure to be like 10 out of 10. She thought that he was definitely trying to kill her. So she comes in trying to get the restraining order. We find out that she had been strangled. We had the protocol to make sure that we do a forensic exam, and we conducted a forensic exam from head to toe. This is day 6 when she finally went to the hospital, because from day 1 to day 6, she thought she was fine and she didn't need medical attention. And because she was a nurse, she was convinced she didn't need to go there. But fortunately, we had an advocate and we had a police officer who were trained, and they wouldn't take no for an answer. So day 6, she finally goes and seeks medical attention. I'm going to give you the short version. The doctor sees her and says, "What are you doing here? You look fine." But she's not going back because she's got an advocate outside saying, you need to get treated. At that time, we were advocating for MRIs as opposed to a CTA. Ultimately, based on what she described, the doctor did give her a CTA. And even though he was ready to discharge her because everything else was fine, when the CTA came back, he realized there was bilateral carotid dissection and everything she said was true. It was as if, the way Tanika described it, is that he did not take her seriously because she did not look bad. She didn't have a black eye. She didn't have any cuts. She wasn't bleeding. So what's the big deal? Once they found out, they went into hyper mode, put her into the hospital, into the ICU, put her under a false name so nobody could find her, and the whole case immediately changed when they did the CTA. So we recommend the CTA to rule out a carotid dissection. However, research has come out now. Write this down. A study that came out of Kentucky essentially found out, this is a hospital where anytime they found out a victim had been strangled or choked, they would automatically order a CTA of the neck. They started to do a retrospective study of all the CTAs that they did for patients who were choked, and they found 1 out of 47 patients had a carotid dissection. And when that study came out last year, I went like, holy cow, again. Finally, we've got some clarity and why we need to be doing this. So carotid dissection is the big one. What is a carotid dissection? I had asked this question too. It's essentially you're going to have injury to the carotid arteries. It could be the veins. It could be the vertebrals. But you can have slight damage that could blow up immediately, or it could take a while for this to happen. So if you have bleeding internally, it can block something and you can have a stroke, or it can bleed externally and the same thing is going to happen. You can have a stroke and or death. Catastrophic. So Dr. Bill Smock and our medical team came up with some recommendations. Our goal is to get every hospital in America to adopt these recommendations so that the strangled patient can have adequate screening, assessment, and treatment. So what you're going to have here is the algorithm and a link to all of these articles, 20 articles. The doctors, it's kind of fun. The doctors make me read their medical articles and I make them read case law. So it's a nice, fun relationship. What I want to do now is highlight the 20 articles they made me read. Overall, here's the history. There was a time, as I mentioned before, that they felt that if you were strangled, you were fine and nothing's going to happen. So that's the way the literature really read. And even today, I think when you look at other types of injuries and cancer and different things that are happening, non-fatal strangulation is under-researched and I think underappreciated, and it's taken us a long time to actually get to this point. So what we have here is one article gets published after another, and each one moves the dial forward. So once we kind of get past, yes, victims are being strangled and survive, the next thing that we realize is that there can be internal injury, and the only way you're going to find out about an internal injury is imaging or an autopsy. So I would rather have imaging than an autopsy. Then there's an appreciation that many doctors have not been trained in this particular area and have missed it. Dr. George McLean, who was an ER specialist, was the first one to admit that to me, and he also admitted that what he would see is domestic violence victims are not taken seriously, and it's very easy that for a victim who comes in, they're going to immediately discharge them with probably an aspirin and take other cases more seriously, not knowing the risk of a stroke. So it wasn't until like 2000, if you kind of think about this is still very early in our research, is that it wasn't until 2000 that they start to appreciate that there were victims who were having strokes under the age of 42, and no one was asking them what happened to them. Strangulation was never a question they used to ask. And the first study that was published, they actually called it strangled wife cryptogenic stroke. And I asked, what's a cryptogenic stroke? And then Dr. Dean Hawley was kind of being a little smart aleck with me, and he said, ultimately, he goes, Gail, it's a medical term saying we don't know what caused it. And for a long time, they didn't know what was causing these strokes in young women. But little by little, we start to get more research, and we start to get a push for national protocols on how to identify it. So then came, which I think is one of the big ones, was the Christie article where they started to do some MRIs. And in the MRIs, they started to document more internal injuries to the brain, to the neck, to the carotid arteries. But ultimately in 2010, we started to see a shift to CTA. And I'm going to explain why a CTA is being advocated by most of the doctors as opposed to an MRI, although the MRI has a better ability to really image internally. So now we get to CTA is preferred. Now we start getting more CTAs done, whether intentionally or by accident, and they start finding fractures of the hyoid bone to surviving victims. They start documenting delayed death weeks after being strangled in adults and in children. We start seeing very clearly that non-fatal strangulation and injuries is very difficult to detect unless you have a protocol. So why CTAs? It's fast, it's cheaper than an MRI or an MRA. We also know that the CT machine is essentially going to be more available at hospitals, and not every hospital will have the technicians who know how to operate the MRI or the MRA, and it's generally going to be cheaper. So I wanted to share with you is that the medical community really relies on what's published. And there's a lot of anecdotal information out there that's not published but is just as important. And I want to share this 2017 study that has not been published yet by a hospital who adopted the protocol for victims who were strangled, whether sexual assault or domestic violence. They did 402 exams, and look at what they found. They found carotid dissections, fractured hyoid bones, significant swelling, herniated disc, miscarriages, stroke-like symptoms, and the list goes on. So victims are having these injuries. We wanted to share something that I just became aware of, and that's what's like the fun part of all of this as we continue to learn. I just recently learned about the Emergency Medical Treatment and Labor Act, and I have one of my law students digging deeper into tying this to the federal requirement to treat people at the hospital. which means that if you have a patient that comes in, you've got an emergency situation, and we believe that strangulation is an emergency medical condition that you, by law, are required, if you are a Medicare hospital, to screen and to treat. You just can't just say, sorry, we're not going to help you. So hopefully we're going to learn more about this and we'll share more, but both Alexandra and Margaret will talk a little bit more when we start putting all the practical stuff together for civil attorneys. So we just recently did a webinar because in order to convince hospitals to do this, they need to hear from their peers. So we got the best leading forensic doctors in the field to do an imaging webinar for us. We had about 1,000 people attend, and we will give you a link to that, and so you can watch that, and they will go through it in detail. So the next question is, how do you convince your client to seek medical attention? And I've asked Alexandra to share some of her tips. So Alexandra?
Thank you. One thing that you have to know is you have to know something about strangulation. You need to be able to believe that these are the medical consequences so you can impart this information to your client. You have to explain some of these consequences to the client. Your clients may be unaware. They may minimize. They may be unable or fearful to share the information. They may not have the money and could not seek health care. The abuser might be present in the examining room. The medical establishment has said not a big deal, so they say not a big deal. The service interventions are usually very time limiting. So if they are exhibiting any symptoms or signs or injuries consistent with strangulation, you have a duty to talk to them about this. You have a duty to explain that most injuries are internal, so just because they can't be seen or others discount what they can't see, you need to attempt to convince your client of the internal risks. One way, and the only way to rule out internal injury, either is an autopsy or imaging. So we can say, let's rule out some internal injury. It would be no different if you broke your foot or your ankle. You would want to, or if you sprained your foot or ankle, you would want to know if it was broken. However, if you have an injured blood vessel, you could have a stroke, you could die. So when you tell your client there are injuries that you can see, how many more injuries can a client not see, or how many more cannot be seen to the eye? So we need to also tell our clients about delayed presentation for brain injury, memory loss, and that, as I said earlier, the initial presentation is never a reliable predictive indicator of the outcome. Additionally, you tell her, I'm concerned for your safety. You need to find a way, for one, to bond with your client, for your client to trust you, so then they hear what you have to say. And there are so many helpful resources. When I started delving into this, I started looking for some of the more important resources. There's the Patch article that talks about women surviving strangulation, a discussion of the injuries, what to look for, and the subsequent emergency health care that you need. What we've learned is that what we've learned from Patch is that, and other studies, is how many women don't seek health care. If the ones that seek are between 5 and 69%, look how many don't for whatever reason. And again, I think it's important to ask your client what that reason is so you can talk that through with your client. Additionally, this is a gendered crime. The prevalence of non-fatal strangulation is higher in women than in men. The studies show that. The research shows that. And as I said, but it wasn't just me, everybody is saying it, and actually I'm looking at what Gail has said. You need to screen, assess, and document. That means everybody who in some way touches that victim of strangulation. You have to read articles because they support what Gail has been saying, what we were saying. They support, and researchers agree with what we've said. What is very interesting, if you begin to do this, you will develop a competence in the issue of strangulation, and then you can go further. You need to assess what your community needs, where you are in your community, what your law enforcement people are doing, what policies everyone has. Is there a system-wide policy from every system that deals with strangulation, from law enforcement to paramedics to courts? You need to know your laws. You need to know what the laws are for mandated reporting. You also need, as Gail said, and I see this as extremely important, what does choking mean to the client? I spend my time switching it around and saying, this is not choking. Choking is the piece of meat. What I want you to focus on is the strangulation. And suddenly, when I then change the term, the client changes the term. But I have not said to my clients in that way, what does choking mean to them? And I think that's something else to look at. So what does your law enforcement is required to do to help victims? California has a duty to warn statute. California, most states have a duty to call paramedics. Ohio does not have either one of those. We have a law that we hope will pass, which will make law enforcement warn victims of the effects of strangulation and the internal injuries. I'm looking at that. That's probably one of the most important things that we can do, because when law enforcement knows, when they begin to assess for lethality, when they recognize that strangulation is a high risk for homicide, then we can make change. You look at the updated IACP DV model policy. The strangulation language has been modified to order that EMS should be called. But as Gail had written in this, all police and sheriff's departments should update their protocols to include strangulation. One other thing you can do is contact your law enforcement. Ask them, do they have a policy? What is that policy? And it should be updated. Now, have your paramedics, your EMS, been trained about domestic violence? Earlier today, Margaret and I talked, and she said that they get an hour or two of training. So that prompted me to call and find out about my paramedics. They get no training on DV. Unless they are part of law enforcement, they do not, just because if they work within the county, they get no training. They don't know what the victim could be experiencing. They don't know what questions to ask. But what is said to the victim at the scene may save that victim's life. It is always important for EMS to ask the important questions, and I know that we have that strangulation assessment card that should be used by everybody. That should be used by paramedics, that should be used by EMS, that should be used by law enforcement, that should be used by prosecutors, and of course, that should be used by civil attorneys. If we were to train EMS, we would be telling them, ask those important questions to identify injuries that may be hidden by clothes or not visible. Look for clues when a victim cannot remember details or is too traumatized. Tell them that you want to provide needed medical treatment and you want to be able to make those transport decisions. And if they are aware of the signs and symptoms, the EMS, they can identify potential victims of strangulation, provide that treatment on the scene, make accurate transport decisions, and properly document their findings. And again, whether it's used in a criminal case or in a civil case, having those documented findings will save a victim's life. One other thing that I think is really important is you need to look at your laws. You need to look at, do you have a law that has medical mandated reporting? Ohio does for felonies, but it's report to law enforcement. So if your EMS is not reporting what they see at the scene, there could be consequences. You have to see if there are any cross referrals to Child Protective Services. In Ohio, we have, for felonies and burns, we have a mandated reporting statute. But for domestic violence, and I put that in quotes, we have a mandated recording statute. We just have to note in a patient's records, known or potential for abuse. And then we look at HIPAA. What has happened in HIPAA, now under the HIPAA requirements, domestic violence has become an exception. It allows for law enforcement to get records where a crime of violence has been committed. So I think this is extremely important. And as I said, there are 5 things that you need to look at. The more you know, the more you see, the more you document. One of the things that I have done with a paramedic that I met with is they couldn't get clients to understand that if they in fact wet themselves, they wouldn't answer the questions. So maybe there's another way of approaching it. Maybe you say, often some of the women I care for who are strangled report they wet themselves. Did this happen to you? Normalize it for the victim. You need to ask about, were there gaps in memory, change in location, unexplained injuries. One of the other things that can be done is, if you're a paramedic or you're an EMS, look at behind the ears, look at hematomas on the face, look at red spots. Don't automatically think some of those red spots could be a skin condition. Look, know, and we will all save victims' lives. To end, EMS must evaluate, examine, encourage treatment, and educate. Then, as lawyers, this is up to all of us to know the physiological and psychological and legal aspects of strangulation, and we should all be trained in the laws of our state as to medical mandated reporting, medical diagnosis and treatment exception, and knowing that EMS can be held responsible for failing to report. Thank you. Margaret?
Well, thank you, Alexandra. And before we go to Margaret, I just want to add one thing. When it comes to laws related to paramedics receiving training, there are only 2 states that I'm aware of, last time I researched this, that actually require paramedics to receive training in domestic violence, and that's Tennessee and Kentucky. And as I've been trying to search for protocols on the domestic violence training, most of them do not include strangulation. So this is an area where I think we can all jump in and help. And now, Margaret, is there anything you would like to add with respect to some of the points that Alexandra made? If not, we will go to who's going to pay for all this.
Yes. Well, Alexandra made some very, very good points. Screen assess documentation, but she repeatedly said, as it related to what she was talking about, know the law. Know your law. The economic consequences as a result of strangulation can be immediate or delayed. So you need to gather your client's medical records and the medical bills, but don't assume that that's all the economic consequence that your client may have suffered. So you need to get documentation of all the economic injury that your client suffered as a result of strangulation. For example, charges occurred for alternate housing, rehabilitation, other remedial treatment of care, family counseling, grief counseling, and in the most unfortunate situation, funeral expenses. So encourage your clients to give you all the documentation of every economic consequence that they have suffered. But before we get to how to pay for it, I want to add a little bit to what Gail said about the Emergency Medical Treatment and Active Labor Act, so that you would know what your client is entitled to. That law's intent was to ensure patient access to emergency medical care and to prevent the practice of patient dumping, in which uninsured patients were transferred solely financial from private to public hospitals without of their medical condition or stability for the transfer. Now, as lawyers, we need to know how to plead certain things. So if you're going to raise a cause of action against a hospital, you need to know what that emergency medical condition is as defined under this law, and the three distinct legal duties imposed on the hospitals. They must perform a medical screening exam. And if an emergency medical condition exists, hospital staff must either stabilize that condition to the extent of their ability or transfer the patient to a hospital with appropriate capabilities. And finally, hospitals with specialized capabilities or facilities are required to accept transfers of patients in need of such specialized services if they have the capacity to treat them. And let's be realistic here. Sometimes people don't get medical care because of their economic position. Sometimes they don't get what they need because of racial issues. And so therefore we need to know that. And so you need to be able to allege in your pleadings that the client, as a result of strangulation, suffered an emergency medical condition because of the severity of the attack that was experienced. So therefore, familiarize yourself with that act, because the person needs to be treated and they don't need to be worrying about money. Now, of course, if your client has insurance, you need to thoroughly review the insurance policy to see what is covered. You can ask for restitution as a part of sentencing, or meet with the district attorney and ask them to make that request as a part of sentencing on behalf of your client, and give them all the documentation of the economic consequences that your client has suffered. And it's not always limited to just medical records. Of course, as civil attorneys, you can ask that in your prayer for relief as you outline in your pleading what economic injury the client has suffered. All right, some medical expenses are waived by hospitals, some are absorbed as a matter of policy. So you might have to go to the business office to see what the hospital's policies are. You may have to educate yourself when you're told, no, we don't do that, we can't do that. It's, well, under this particular law, under this particular regulation, I beg to differ. So let's see if we can change the course of this conversation. You may ask the hospital to see if you can negotiate the bill, particularly when it comes to CTA exams. Our research has shown us that clients have been billed as much as $5,000 for a CT examination. So therefore, do your research and say, well, no, you charge $5,000, but it only costs you $600 to administer the particular examination. So let's look at this bill very, very carefully and see if we can reconsider what you have billed the client. Always stress what is a medical necessity in your pleadings. This was a medical necessity. A client who's been strangled, medical care is a medical necessity, both immediate and delayed, particularly depending on the consequences or the medical issues that surface after the initial examination. So be aware that costs may vary, and challenge the bill. Negotiate it, ask them to waive it, be creative in your pleadings in trying to deal with that. Now, how do you get medical bills paid? Okay, if your client's insured, of course you present that. If your client isn't insured, apply for Medicaid. Consider filing a separate tort action for assault, battery, intentional infliction of emotional distress, invasion of privacy, negligent infliction of emotion, and false imprisonment. Consider the kinds of damages that you can get: compensatory, special, and punitive. But know your state's Crime Victims Compensation Act, or whatever it is called. In North Carolina, it is called the Crime Victims Compensation Act. So you have to know who can file a claim under this act. You have to specifically know what services are covered. You have to know how to apply. You have to know what the statute of limitation is on filing a request under this law. And you most definitely, under the North Carolina law, have to know the effect of collateral resources on an award. Are there other economic benefits available to your client that will impact and affect the amount that they can get under the Crime Victims Compensation Act? So you have to study the economic consequences carefully. You have to advise the clients from the time you initially see them to save all your bills. Just tell them, get a brown paper envelope, everything that comes, put it in an envelope in chronological order, but not just to ignore it, but to look at it and to bring it to you. Another resource that you need to take into consideration is whether or not your client lost wages or whether or not your client lost their job. Because sometimes, depending on what the situation is, people can lose their jobs because they may not have sufficient leave, or they may have a situation, if you're out a certain number of days, then you'll lose your job. Strangulation victims have a serious psychological effect. Sometimes they may forget things. They may not be able to articulate things quickly. If your client lost their job, talk to the medical provider to see if they've suffered any of these consequences, and maybe you can renegotiate with their employee to say, well, they were experiencing memory loss. They weren't at that time where they were not able to follow the specific directive in whatever chapter of the HR regulations that required them to do A, B, C, D, and E, because they weren't able to do that at that time. So you have to be creative in looking at all of the economic consequences that your client suffers as a result of strangulation. And you can purchase the ABA handbook on tort law and domestic violence. And if you notice there on the side, one of the things that is discussed is restitution. So, as excuse me, Alexandra said, study the laws that are applicable in your state. Document, document, document. Include every single economic injury that a client has suffered, that client's children, though any economic injury that is directly related to this horrific act of strangulation, and put it in your pleadings and in your prayer for relief, and see if you can get adequate justice and offender accountability for your client. Gail?
Okay, thank you.
Gail, can I just say one thing as it relates to the strangulation assessment card? Somebody wrote in the chat box, wondered if the advisal to patients can be copied and used for their clients. It's my understanding, yes, the answer is absolutely yes. You can take some of these materials and make them your own. Is that correct?
That is correct, Alexandra. We are here as the Institute to create these tools. If you go to our website, you will see a lot of these tools. We're going to be making the tools that we're talking about in this webinar available to you. I am a big fan of the strangulation assessment card. Initially, it was created by paramedics for paramedics, but we soon realized that anybody and everyone can be using this strangulation assessment card to screen your clients, whether it's a 911 operator, a hotline worker, civil attorney, advocate, paramedic, therapist. Everybody that's on this call can make good use. In California, they use that tool to actually comply with the law, which is the duty to warn. And as you can see now, the more you learn, the more you realize, I think we have an ethical duty to screen and warn about this. So a frequently asked question that we get is, how do you get your hospital to adopt these recommendations? It was the top question in the imaging webinar, and I wanted to kind of share this because I'm hoping some of you on this call have already adopted it and you're having a great conversation and asking questions and answering questions, which I've never seen before. It's like a freeway happening here and with just tons of great information and exchange of information, which is like the coolest thing I've ever seen. But anyway, going back to how do you get hospitals to adopt this? We have seen people, it can take one person who is influential, who works in the system, your director of your hospital, the medical director, and it can be as simple as what Barb, one of the nurses that's part of our advisory team, Barb Bachmeyer, she just emailed her medical director, gave him all of the information that we are sharing with you and we have put into the imaging toolkit. He read everything and it was done. The other way I call it is the power of we. You bring a team of people to go to meet with the medical director or whoever is in charge of this policy and you make your pitch. I call it the 5-minute pitch, business case on why imaging is important. And if anybody reads those 20 articles like I have, and I read them like probably 5 times, I have even a PowerPoint more than what you already saw that I'm happy to share with you, I would say take a look at the imaging toolkit. It gives you everything that you need. I say invite them to training. Sometimes they need to get there by themselves. They need to hear it for themselves, process it, and then they adopt it. We find that people who go to trainings together as a team, that police officer, that prosecutor, that civil attorney, that advocate, that doctor, that paramedic, that therapist, your probation officer, all of you, judges have been going through this training. You all have this aha moment at the same time, and I've seen your minds just start racing. And they have like this action plan for the first day of training, what they're going to do when they get back home. We have had problems where you've got a hospital to adopt it, and then it goes to what I discovered, this insurance doctor. I don't know where they live. They're like somewhere deep in the shadows, and all of a sudden everything is going well. We get the CTA ordered, we can get the CTA, and then they don't want to, the insurance doctor doesn't want to pay for it. Well, then we decided to write the Dear Doctor letter. The Dear Doctor letter goes into a deep explanation as to why this is important as opposed to that one sheet front and back, because some people do not take the time to read those articles. I know that might shock and surprise you, but it's true. Then, of course, threatening to sue them, using the L, love word or liability word, sometimes works. But I will tell you this, is that we're now tracking civil lawsuits. And one lawsuit that cost the hospital about $6 million, it was a coach. The coach goes into the hospital. He was having symptoms of a stroke. He was a coach, wrestling coach, and they go in, they examine him, they give him a CT, not a CTA. Apparently the CTA kind of gives a better, clearer picture of what's going on. So they give him a CTA. They say, hey, you look fine. They release him. Thank you very much. He has a massive stroke within 24 hours. They cannot settle. They end up going to trial, and the jury came back with a verdict of over, I think it was $6.3 million. So the research, when you start to read the research on the stroke literature, they actually say an aggressive policy to screen is that you're going to be money ahead, even if you have a negative finding. So one concern that doctors have or hospitals have is like, we're going to do all of this CTA and there's just going to be a bunch of negative findings because the research doesn't really show that this is a really significant or serious thing. Well, now we're getting research that says, yes, 1 in 47. Another study that was done randomly, pulling just cases, not all consecutively, found 1 in 75. And that is huge because before that, everybody thought it was like 1 in 1,000. So lawsuit is something that you can do. We don't want to go there. We're hoping that we can make the argument that this is an emergency medical condition, that this is a medical necessity, as others have said. So a couple of more things that I like to use is New York. New York issued a medical alert to the entire state. Thank you, Andrew Cuomo. He ends up saying to all of the doctors, all the hospitals, that when it comes to strangulation, it's happening more than you realize. There's internal injuries, and we need to be doing a CTA, and we should be following the recommendations of the doctors from the institute that have put this together. And they even go in and make a duty to warn. Next, now this is in the entire state of California because all this stuff takes a lot of time and energy. Now you can understand why we're trying to multiply. San Diego County took New York's medical alert and created a San Diego County medical alert to all the hospitals in the county. Love them, beautiful, amazing team of folks that made this happen. I like the power of we, because if you bring in your coroner, your ER doc, your nurses, your prosecutor, your police officers, and you say, we want to meet with the medical director, I doubt if they're going to say no, and I doubt if they're going to say no to you. Look what San Diego did, and this is available to you. Got San Diego's permission to take everything else off, and then you could put all of your logos on. They said, you know, if we're really going to make a dent, we got to bring this to everyone's attention. So they created their own poster. Only you decide what goes on your neck. I think it's amazing, and we're now putting it everywhere. So that's an option. And then we thought we'd get, yes, we are like ahead of schedule today. I'm so excited. This means now we get to go to the chat room, which still looks like a freeway, but fortunately Anya has been pulling this all together, and she will start sharing some themes or questions that have come up that have not been answered by others that maybe one of us can answer. So Anya, how are we doing?
Hello. Well, first of all, thank you to the three of you for all of that incredible information. It was so helpful to learn about the physiological and other sort of responses and traumas related to strangulation. I learned a lot myself, and we have a lot of questions, some of which you did dive into, but perhaps they could be expanded on, and some that are new. One of the first sort of set of questions are related to, and my pronunciation will not be correct, but is it Petechiae? Petechiae?
Petechiae.
Petechiae. And Noelle and Allison both had questions. Noelle actually had a question sort of about the relationship to seizure. And so the question is, have you come across cases where the respondent's attorney argues that the violent act was not strangulation, but rather related to an epileptic seizure? My understanding is that seizures can cause petechiae too, assuming that the perpetrator is denying the act of strangulation occurred at all, and also assuming the survivor has a history of seizures. And then another question related to petechiae is around how long the petechiae itself remains visible. So how long would it be a physical type of evidence that could be documented?
Okay. So when it comes to those tiny little red spots called petechiae, the research says it's definitely life-threatening. The research says that it generally happens after continuous pressure for a good 15 to 30 seconds. The seizure defense comes up quite often, trying to say she has a history of seizures, and I'm wondering, okay, why does she have a history of seizures? When did it start? Knowing that medical history would be important. I would immediately talk to a forensic nurse who can read the medical records, because I generally can't, and help me explain this. So the first time I learned of the seizure defense was in a homicide case. He said she was having a seizure and she died from a seizure, and it had nothing to do with strangulation. Well, this is where I think the medical experts will come in handy to explain this. Generally, the hypoxic nature of lack of oxygen to the brain will trigger a seizure. And I think that's what is key. He caused that seizure to happen. The fact that you might have petechiae, I don't recall any of the doctors testifying to that, so I would have to probably double check with our medical advisory board about that specifically. But we've generally said in order to have that seizure, two things will either happen. One, you applied pressure and then you let go, and then we have seen a seizure when that happens. The pressure is released. We have also seen a seizure when there's continuous pressure because the body is still reacting to a lack of oxygen. So nurses, forensic nurses, many of who are on this call can easily tie that in. And with the 15 to 30 seconds that generally petechiae is going to form, I would say that's more consistent with pressure being applied than the seizure, and the seizure is more consistent with the strangulation. We have used witnesses, and sadly sometimes it's the kids, who will say, I saw mommy shaking. And the suspect, the respondent in your world, also sees exactly what's happening. And if there's a history of strangulation, they know exactly what they're doing. And the fact that they're still holding on for that long, to me, is actually evidence of intent to kill. Now, with respect to how long does it last, well, we're still learning. Generally, what the doctors have seen is that it will disappear within a matter of days. However, because a lot of this information is not documented, I have talked to detectives who have seen petechiae still present in the eyes much longer than a couple of days. And the more petechiae that we generally see, because sometimes it's completely red in the eyes, and I didn't put a lot of pictures of all the petechiae cases because of our time, but that means that there has been repeated pressure applied. So you apply it, you might fight, you release, and then they reapply, and as I said before, the clock starts all over again, then you're going to see more and more of it. So generally the experts have told me that they believe when they see more petechiae, that generally suggests a struggle, repeated struggle to stay alive. So I think that was that first question. Hopefully I answered that.
Yes, I believe so, and I'll allow the question asker to post in the chat if there are any follow-up questions. Thank you, Noelle. I think that was a great spot-on answer, Gail.
Okay, good. Phew, we've got a lot of nurses out there, and if they can all help me. We're a bunch of friends here today. You might even have a doctor, who knows? Okay, so we'll go to the next one.
Sure. So the next question is specific to a type of strangulation or scenario. And Katie wanted to know if you could speak more about strangulation that's caused by one person sitting on the other person. She's had several cases like that, and she'd like to know more about the injuries that are specific to that type, as well as how to explain it and educate the court and the judge.
Okay, so what she's talking about is positional injuries. That's when somebody is sitting on top of someone and is unable to breathe. So you can't fully inhale, you can't necessarily exhale, so you're slowing down the breathing process. What I've learned in talking to survivors, cases I've handled, and talking to the experts is that generally that suggests that a victim may have been strangled once. After you strangle someone and they pass out, everybody gets to the ground. When they come to, sometimes it's a matter of a couple of seconds, they might bounce back. But the more you get strangled, the harder it is sometimes to bounce back. Once you bounce back, the first thing you're going to try to do is get the heck out of there. So many victims have reported trying to run. Then they get dragged. So the victims in one of our focus groups, they actually told me this. They said, Gail, you're missing this question. I go, what question am I missing? She goes, hair pulling. There's a lot of hair pulling as they're trying to drag us back into the house. And then when they try to drag us back into the house, they're restraining us, and they restrain us in many different ways. One is just sitting on top of the victim and then not only restraining them there to hold them down, sometimes for the purpose of sexual assault, sometimes it's just to get a better grip of someone's neck, and that positional asphyxia will happen. What could be some of the signs? It could be consistent with the signs and symptoms that we shared in that strangulation assessment card. Some of the doctors who have testified to this is that there can be either the brain damage because of the lack of oxygen to the brain, ultimately death. You can also have some of the injuries that I talked about before. If there was a seizure and you ended up being nauseous, you vomit, you can have damage to the lungs, that aspiration pneumonitis. You can have the lungs kind of essentially fill up with liquid, which is kind of consistent with drowning. And then we have seen problems with pneumonia. We have also seen victims report problems with swallowing. It's really case specific as to where pressure was applied and for how long. But I would say the best document to read is one of the documents I referred to that explains positional asphyxia. Is this something that I think we need to be asking about, especially those advocates are getting restraining orders for victims, is method is key. Now, the next session that we have together, Alexandria and Margaret will go through our top 10 questions to ask. So hopefully I answered it sufficiently.
Thank you, Gail. I can allow, again, the person who asked the question to comment with any follow-up questions. But for now, shall I move us forward? And then if they comment, we can go back. The next question is one that goes to the section around costs. And a question from Marisha was that have there been any suits that have been brought against hospitals for failing to treat strangulation cases in violation of EMTALA? And a related question around costs is around Office of Victim Services paying. So there were some touch points to this, but I think maybe a deeper dive into violations and as well as cost coverage would be welcomed, especially I think from a civil arena, but also in other contexts.
Okay, so I'm going to ask Margaret to answer the question about VOCA and or Alexandria as they try to compensate their clients through the victims of crime. And then I can answer the federal law. And I'll answer that real easy is I don't know, but I'm going to find out. I've asked one of my law students to research this. Their paper is due in 2 weeks, and I'm happy to share it if it's worthy of other people reading. Not all the papers are A papers, but I've asked her to specifically find out if anybody has been sued under that federal statute. Absent that, I have been tracking a couple of other cases where primary doctors have been sued for taking their sweet time to order a CTA. So in other words, victim doesn't go to the emergency room, she goes to her primary. She tells them what happens, or you figure out what happens. And then the doctor orders, okay, you really should get a CTA. And then they wait like 5 days or a week or 2 weeks until they can get an appointment. And then the bad thing is that someone has a stroke in between. I have seen cases where primary doctors have been sued for a delay in ordering one. But that research is not exhaustive. This is the area that we're now going to find out more. But from what I can tell, there is statutes and case law that would support lawsuits against the medical community for failure to order it quickly, failure to order the right imaging. So I'll leave it at that and ask Margaret and or Alexandra to answer the VOCA question.
Recently, here in North Carolina, we had a lady, she wasn't strangled, but she was severely injured as a result of very bad domestic violence. And she suffered injury to some muscles in her arm. And in the complaint that the lawyer that I hired to represent her, we put a damage claim because of the medical injuries she had suffered. Before we filed it, I conferred with the grant manager because we function under a VOCA grant for this program. And we were told specifically that we could not file a VOCA grant, a damage claim for her under VOCA. And there is a federal regulation that justifies it. I had to research that. I don't remember the number right off the top of my head, but I can get it for you. That did not preclude, however, her filing an action herself as the plaintiff against the defendant for the damages that she had suffered. But we could not use the VOCA funds for that specific purpose. I was told by my grant manager, and the federal regulation supported that.
And all I can say under VOCA, just like other domestic violence cases, we've sought and received money, but it wasn't never specific to strangulation.
Mm-hmm.
So one thing I have learned when it comes to filing these claims under victim compensation is when you do local training, it is a really cool, smart idea to invite your representatives who manage these applications and or approve or disapprove them. Once they go to the strangulation training as well, they're going to be like one of your biggest advocates to ensure that the victims are compensated for their medical expenses. Anya, back to you.
Sure, thank you. And I think that there might be a follow-up question in the chat related to the inability to apply because of grant constraints. But Marisha is curious if you're still able to assist the client in her claim.
I function under a grant, and I can't at the same time represent people personally. Under my grant, I do hire what we call contract attorneys who are members of the private bar. And I had a conference with that lawyer, and if the client wanted to get a lawyer to pursue that claim on her behalf as an individual plaintiff, I had no problem with that. But I could not pay the lawyer to litigate it for her. So I was not able to assist as the project director for this particular grant. But I did have some conversations with her private counsel, but whether or not she wanted to hire the private lawyer to pursue that claim on her behalf was an individual decision that fell outside the scope of what I can do.
Thank you, Margaret. And I believe that the person who asked the question is saying thank you and they get you. In case you don't see that in the chat, I think they just wanted to hear more about the story.
I see it. But like I said, every time I've talked, be creative. Just because it may be something that hasn't done before doesn't mean that there's not a cause of action out there that you can try, or try another law to try to address the client's needs, because we are developing these procedures on behalf of victims of strangulation. So even if it's denied or dismissed, keep doing it.
Thank you, Margaret. The next question, actually, your use of the word creativity goes directly to this. And one part is about experts. Our experience at the ABA and training civil legal attorneys is that the vast majority have not used experts in their cases, not out of a sort of lack of desire, but a lack of resources or funding to pay for that expertise. And so there's a two-part question that's come from a few intake questions. One is, what are ways that you, as lawyers, have creatively been able to bring in the valuable expertise of medical professionals, nurses, and strangulation experts in these cases? And then also, for those who are unable to, due to time or resources, have an expert in a case, how do you get this information before the judge? What have been successful strategies?
I would love to talk about that. First of all, if you read your case law, an expert can be any discipline. Your law enforcement officer can be an expert. Doesn't have to talk about your specific case, but can talk about strangulation. A forensic nurse that you're friendly with can be an expert. Your advocate could potentially be an expert. We should all be groomed to become those experts to help. Now, what I have done, and I've done this more and more, is I've used briefs besides affidavits from my client where I asked all the questions. How did this happen? Was this from the front or the back? Were there ligatures? What did you say? What did you see? What did he say? The more you write that, you're creating and developing a story that the court has to hear. Additionally, you can file a brief in support of, let's say, your protection order or your custody case or your monetary case, and include a lot of the articles that I know that Gail has commented on and that we've talked about. And even if the court denies it, the court will read it. And to me, that's the most important thing. And you move on to the next case. You do the same with the next case. And eventually you're going to get people to notice. You're going to get people to understand strangulation.
I'd like to add to what Alexandra said. I agree wholeheartedly. Fortunately, here in our Family Justice Center, we have a young lady who attended the Strangulation Institute out in California for 4 days. Even if you don't have a Family Justice Center, see if you can get your law enforcement officers to go. See if you can get someone from the Victim Witness Center in the District Attorney's Office to go, someone who can go to that specialized training, because it is really amazing what is taught there. So you don't have to necessarily have a Family Justice Center in order to try to find someone in the spectrum of delivery of services to strangulation victims to go to that training and become certified as an expert. I would highly recommend that.
So this is Gail. I'm just going to add one more thing. Is this is a real issue that comes up all the time. So when we were trying to start passing new laws and trying to get prosecutors to prosecute these cases as felonies or handling it in civil cases, the first thing that ended up happening is that we have no such thing as an expert in strangulation. That was the first one. The second one was, well, even if we had an expert, we can't afford to pay them. And I went, wow. And then the third argument was, judges are not going to allow it. I go, wow. So they got all these excuses as to why it can't happen. So I said, well, let's turn this around. And then the question is, how can you turn it around? And then what I realized, all around me were potential experts. As Alexandria and Margaret said, you got to know the law. And generally, anybody can be an expert if it's going to be helpful. The law also says it's a very low standard because can it help? And the case law now is very clear. Strangulation, whether by manual or ligature, is beyond the common knowledge of the lay person. Defense attorneys or your opposing attorney is going to say, we don't need an expert because everybody knows about strangulation. All you got to do is watch it on TV, but they don't know all of it. So the good news is we've got case law now of detectives, paramedics, and I love paramedics because paramedics, they generally, you can subpoena them and they will come. Police officers, you can subpoena them and they will come. Forensic nurses, if they're part of the team, they will come. You have to probably work out for some, but what I have found is if you reach out to folks and say what you're trying to do and will you help me, they will help you. So I always say go make a friend. Go find somebody that will come play with you, learn with you, and be a pioneer. All of us are doing this work not to be rich, but to help others. So that's the good news when it comes to that. So I would just say play with it. One of the things that we did as a prosecutor to try to get this to work, I said, okay, I lost my first strangulation case. I think I lost my first argument to get a strangulation expert, but I just kept trying. I just kept trying in other ways. So one way was bail hearing. I went, oh, the burden of proof there is much lower. I can call just about anyone at a bail hearing. So I called the detective to go and testify, and he, of course, testified for free and then educated the judge. Then I learned the affidavit trick. You can attach any kind of affidavit to any kind of document. And then I learned judicial notice trick. You can attach any kind of document you want. Now, will the judge rule in your favor all the time? Probably not. But as Alexandra said, make good use of trial briefs, affidavits, judicial notice, and attach, and go make some new friends to try new things. And then, of course, how I met Dr. George McLean, I subpoenaed him to court, and he was the first doctor to actually return my phone call. And anybody that you issue a subpoena and returns your phone call, that's the expert that you need to make friends with and groom, and then bring a team. Like right now, if you go down this list, I'm seeing people who are experts. There are forensic nurses. I see Dale from North Carolina. I think Sonia was on here from North Carolina. They're testifying as experts, whether you're an advocate or a police officer, paramedic, or nurse. It's like the coolest thing. So thank you for asking that question. You can see we're all very passionate about that particular one. And we still have like 15 minutes to go. How cool is that?
Well, thank you all. At the ABA, we are exactly on the same page about expertise and experts, and train and teach about being creative and thinking beyond sort of old tropes of who can be an expert and who has knowledge that can help inform a case and help a survivor. So I just want to say I agree with what all of you just said. Did someone want to jump in? Was that Margaret, before I ask the next question?
I was reading the comments by Monica Martinez in the chat box. She said this doctor wouldn't, said that the patient did not meet any criteria for neck imaging second to injury, even though the patient said she had been choked on multiple occasions. I would strongly recommend to you that you carefully read the Emergency Medical Treatment and Active Labor Act and ask that doctor to justify medically whether or not this lady was, I assume it was a lady, whether or not she was suffering from an emergency medical condition, particularly if she had been, as she said, choked multiple occasions, because as we said in the first webinar, her the likelihood that that lady may be killed is very, very high. So that's really disturbing to see that she said she had been choked on multiple occasions and wasn't allowed to get any imaging for any injuries that she may have suffered. Be a persistent, polite, professional pest.
I love that. I also call it gentle, relentless pressure. So a trick that one of our advocates uses, that she always sends her victims at the Family Justice Center when they seek medical attention, if she can't go with them, she sends them with the strangulation assessment card. And on the second side of the strangulation assessment card, there is a notice to medical providers. And in that notice to medical providers, it specifically refers to the imaging recommendations, which New York sent a medical alert saying you should adopt it. If anybody reads the 20 articles, you will know that it is clear and convincing and persuasive that you need to have imaging. Then, of course, you have the Dear Doctor letter, but I would also say you can contact us, and our doctors are so adamant about this issue that they're willing to take a call or make a call to an emergency doctor, emergency room doctor, and doctor to doctor, peer to peer. They're willing to make that phone call and advocate for your client. I have seen our doctors do it, and I would rather have kind of force them to do it, have a negative finding, and feel at ease and take a deep breath that nothing bad is going to happen to this person. But I would say the best way to do it is in advance, trying to get the doctors, the hospital to adopt this protocol. But in the moment, if you're having a problem, just reach out to us, and we will try to get a doctor on the phone with someone in your community.
Hey, Gail, medically speaking, how long after an incident will the imaging show something?
That's a good question.
And also, no. And then, 6 months, a year later, can that same person have it?
Yeah, I thank you. I didn't mean to cut you short. But what Dr. Smock recommends, because this question is asked very frequently, is that it's always going to depend, but he generally says if she's had no symptoms or any kind of consequences from it within 1 year, you're probably at the safe mark within 1 year. But in one of those articles that he cites to, in the 20 articles, they actually have a chart which they have documented women who have been strangled, mostly it's been women, that they have had strokes days, weeks, months, and years later. But he feels comfortable with the 1 year mark.
I'm glad that you all just answered that. That was a question in our chat now, and there was also a question earlier from Karen about if 3-week delay in imaging would it still be worth it to get a CT or other type of imaging? So the answer seems to clearly be yes.
Yes. 3 weeks, yes.
So I want to thank the three of you. I think now there's a great need for resources for all of our participants, and I'm actually really excited that we have 2 more sessions to dive deeper into other sort of related and parallel pieces of this larger picture. So perhaps, Gail, what we could do now is talk about the next steps, the resources, and then wrap up and get ready for our next session.
That sounds great. I just realized something. Did I talk about state versus Washington versus Till yet? I don't think I did, but I wanted to.
Not today. Not today. And actually, someone asked about it, so that would be great if you could do that.
Okay, great. So hot off the presses, as of June 23rd, 2020, in the state of Washington, an unpublished decision, meaning that it's published, but it's not binding authority. However, I love reading published or unpublished cases because it tells you a lot. So here's what happened in this case. Mom ends up getting prosecuted and convicted for hitting and choking her 6-year-old son. She actually put her son in a chokehold, gets convicted, then appealed. And when she appealed the strangulation statute because she says, hey, there's not sufficient evidence to convict me. My son was crying, yelling, and screaming the whole time. And if he was doing that, that means he was still breathing and there was no obstruction to airflow. And I'm going like, oh my gosh, what is the court going to rule? As we know, that was the big issue in the George Floyd situation. So at page 5, the court, I'm going to quote this, just because SWT could scream and yell does not necessarily mean that his airway or blood flow was not at least partially obstructed. Additionally, just because SWT, the child, did not claim he had difficulty breathing or felt lightheaded does not prove that his airway was not partially obstructed. Oh my gosh, when I saw that, I go, thank you very much. And what that tells me is that what we're seeing in the case law, as the case law is interpreting the strangulation statutes across the United States, consistently they have held you do not need to show complete obstruction of airflow or blood flow, because that would defeat the whole purpose of these statutes. Because if you were to wait until you can prove somebody can't breathe anymore, that means you're going to have an attempted murder case and or death. And that's not the purpose. The purpose is to intervene early. So they have consistently said partial obstruction is all that we need momentarily. New York ruled 2 seconds. There's a case from also Washington, which is the Hendricks case, and there was a woman who was strangled once for 1 second, and then he strangled her again by putting a pillow over her head for 5 seconds, and the court specifically says there is no time to this. The only requirement is to show partial obstruction, not complete obstruction. And sometimes the courts have to jump in, as you all know, to fill in the blanks from what the statute specifically says, and they do that when you consider all the other case law that has been published and or binding. So a lot of good cases out there, and I felt that that was a very timely and important decision that I wanted to share with all of you. So thank you for letting me do that, Anya. And yes, now we can go to next steps, next class, and more resources. And I'm going to advance the slides. Okay, so the next time we get together, this is not right, because I think our next one is going to be the 3rd, not the 4th. There we go, went too fast. Building your case. We're really looking forward to this one because this is where Margaret and Alexandra get to share their tips on the civil practice. I've been a civil attorney not as long as they have, so I can just share my tips as a prosecutor and the limited time that I have had now handling civil cases. Then we're going to go into advocating for your clients. This is also going to be a lot of fun because it's just rich with practical tips and tools and resources to do a better job of advocating. How you can reach me, this is my email address and my cell phone number in case you have that emergency situation where we need to talk to somebody in the ER room now. You can reach me and I will reach one of our doctors. I'm going to also turn it over to Margaret so she can say one last tip of the day.
Just be diligent and don't be discouraged when you run into roadblocks. There's always a cutting edge of the law, and in a way we're on the cutting edge. We're trying to develop a comprehensive body of services, legal services for victims of strangulation. So don't be discouraged. Keep on doing the best that you can, and the main thing is getting our clients to a place of safety and victim accountability. Awesome. Offender accountability. Excuse me.
Oh, I know what you meant. Okay, Alexandria?
I would say just keep trying. That it doesn't matter if you lose one case, doesn't matter if you lose the next case, you keep trying because every case you're moving the needle. Each case, even if you lose, you are educating the court. And educating your client, and that to me is the most important thing so we can end up saving more and more lives.
Perfect. And of course, thank you to our funders, our OVW friends, and also back to Anya for your last comments from the ABA.
So thank you. And again, thank you to Gail and Margaret and Alexandria, and also to Carly at Alliance for Hope who helped put this together, and on our team for Jane and Sylvie. We're grateful for everyone who came together to make this series happen, and we're excited that we have 2 more sessions coming up for you. For those of you who are attorneys, especially civil legal attorneys, we are one of your OVW, Office on Violence Against Women, technical assistance providers. We're here to provide you with one-on-one support in Zoom office hours, the old-fashioned telephone, email. Our job is to help you do your job. So we're here for you. I put the TA link into the chat, perhaps 400 times, maybe 300, so that you can find us. You can also, it's a fact, and you can also find us on our website, americanbar.org/CDSV. We have statutory charts, trainings, webinars, such as this one that are coming up for you. You'll also find in the chat box, both Carly and I shared the TA contact information for Alliance for Hope. Both of these organizations, we're here to help you, so please do that. I also want to thank Stephanie and also Daniel at the National Council who helped do the tech aspects of this, and our invisible to us but ever working captioner. Thanks for all of your closed captioning. So thank you all, and we look forward to seeing you next time.
Thank you, Anya.
Thank you.
Thank you.
Bye.